Well, and again, greetings, everyone. Today is Thursday, Thirsty Thursday, in the country of the Crotchety Old Men podcast. Welcome. My name is Gary Smith, and I'm one of the hosts of the Crotchety Old Men's podcast. My professional career has always centered around financial things. At one time, I was an insurance agent and turned real estate agent. Actually, I was a real estate agent first, became an insurance agent. My career spans from both residential as well as commercial real estate. Having recently retired about 7 years ago, I took on the challenge of helping others do the same. And so, with me today in the studio is my partner in crime, George Crumley. Good morning, George.
Morning, Smitty. How we doing this morning?
Man, we're doing super fantastic. If I had wings, I'd take off and fly.
That's always good to hear. Always good to hear. Always. It's another beautiful day.
So what's going
It's
on, George?
Hey man, it's another great day, and I'm so excited. We've got a special guest today. I'm going to turn it over to my brother PC over there. He's going to introduce himself, obviously, and then he's going to jump into our beautiful guest today. What you got, PC?
George, I'm sitting here with the two of you guys, which is always a blessing. And have Oronda Smith today is going to be our special guest. She has a plethora of knowledge on state planning. And so we're going to interview her today.
Yes, I understand. Oronda is with O.M. Smith Law Group, LLC, located in Morrow, Georgia, which is about 10 miles south of Atlanta Airport. O.M. Smith Law Group represents clients in family law, which includes both estate planning and real estate law. Welcome, Oronda.
Good morning, everybody. It's a pleasure to be here today. Thank you for having me.
Well, today our subject is estate planning. So why don't you tell us a little bit about what estate planning actually is?
It's a great question. First, I'd like to tell everybody that everybody has an estate, and that means that everybody, at least from about the time they're 15, owns something, has some things in their possession, and can make decisions regarding whether those things in that possession go to a particular person, a group of people, or what happens to those things that belong to them if they are no longer able to dictate their wishes or tell their wishes to their loved ones, or if they pass. It gives them instructions. It gives their loved ones instructions on what to do once they've passed. It's important that we get that planning done sooner rather than later, because unfortunately, we neither know the time nor the place.
So let me ask you this. What is involved in putting together an estate plan?
Well, there are a number of components for the estate plan. The first thing I like to tell people to do, and the easiest thing, is if you own a home, just take a look at your deed. Or if you own any real estate, take a look at your deed. If you're single, then you should be the only one on your deed, unless you have a significant other that you'd like to add to it. If you're married, ideally, depending on the financial circumstances, one of the easiest estate planning devices is to add your spouse onto your deed as a joint tenant with right of survivorship. That means in the event of either of your deaths, that property would transfer automatically to the other person. Other than that, estate planning involves powers of attorney, designating somebody to speak on your behalf if you're unable to, and wills and trusts. Those are the main components of estate planning. Also, it takes into account a number of insurances as well, but those items are usually designated more toward financial planners or insurance agents as opposed to attorneys.
Well, let's start with will and trust. What are the differences?
A will a will is a document that designates what you want to be done, who you want things to pass to at at the time of your death. It's generally, it can be a very simple document that says, my property goes to one particular person, or it can be a very complex document that designates a number of people that you pass your belongings to. The difference between a will and a trust, while a trust also can dictate what happens after your death, the trust allows you to put conditions on when something passes, who manages it, and it appoints a person, a trustee, a third party, to control those assets and that property, to the benefit of those people you designate as beneficiaries under the specific terms you outline. I call trusts the document that allows you control of your heirs beyond the grave. The will gets rid of your property immediately without your being able to control how a person spends it, or in what scenario they get to spend it. A trust, you get to put specific provisions in there to designate when somebody might get the benefit of your property.
Okay, well, so what information would I need to start a will and trust, or an estate plan, should I say?
So most attorneys have quite a lengthy questionnaire to start your estate plan. Um, at a minimum, we'll need to know your name, address, just basic constituent information, and who you might want to designate as your attorney in fact. That's the person in a power of attorney that would make the decisions for you or on your behalf. They're called the attorney in fact. For your powers of attorney, we'll need to know who that person is, or who those people are, and perhaps backup people if that initially appointed person can't perform. And then the same thing for wills. In a will, the person you want to designate, or the person you designate to control everything or to administer the estate, is called the executor of the estate. They don't get to just take everything for themselves, but they're responsible for complying with the law and making sure everything passes, or that the will is followed, and that the state law is followed in conjunction with the will when they're administrating the estate. So, in continuation with your question about the information that we'll need, it's a lengthy questionnaire about your assets, who you want to get things, your designees, if there are any charities, how much property you have. It's an intensive examination of every financial aspect of your life, basically. We ask for it all sometimes it's a 20-page questionnaire, depending on how many assets you have, if you have multiple properties, if you own businesses. All of those things have to be disclosed and dealt with. And the reason is because there are certain tools that lawyers have in order to protect, or possibly protect you from, estate taxes and liability from the government as well. So it's important that you disclose all your property, all your assets, and it's helpful even if you close some liabilities or some concerns that you might have about family members and any disagreements that they may have.
So let me ask you this: you were talking about executors and so forth. In a medical situation, um, who would you say would have the authority, the spouse or adult children, once somebody passes?
So that depends. Um, the if the person has taken the time to put in place an estate plan and has a will in place, that person who died got to designate who they wanted to be in control of the estate. Sometimes it's not in the best interest of the estate for it to be the spouse or the child. It may not be the oldest child. You have the choice at the estate planning portion to put the most responsible person in charge of the estate, the person who you think is most reliable and who has the resources and capability to get the job done.
So, what would you say is the ballpark cost for an estate plan?
So I will say that the least expensive part of an estate plan are powers of attorney. And those usually range less than $300 a piece. Next in line is your will. Your simple wills start at around $450 and increase from there. Some people have very complex estates and complex wills, so they can go up as high as you imagine, depending on the assets. And then your trusts begin at around $1,500. So if you have a combination of all of those, then you're looking at usually around $2,000 to $2,500 to develop quite a comprehensive estate plan. Some people don't need all of that. So that's why it's important to research and choose a lawyer, get references, somebody you might trust that won't price gouge you and just try to give you everything when you don't need it. And just really take a look at your assets and the things that you own and let you know which of those things or what out of that package you need.
So, let me ask you this: can I do this online? Can I look this up and get the paperwork and do it online without an attorney? And I know you're going to look at me funny, so I'm glad we're not looking at each other per se.
Well, I'll tell you honestly. So there are some things that you can do online. Um, there are online wills. There are online power of attorneys. There are even online trust templates. What I will warn you about, though, is 90% of the time that people bring those to me, they have filled them out wrong. They have used a document from a wrong state. They have answered the questions incompletely, and it doesn't do what they intended for it to do. So while yes, you can do these online or pick up a will. I've seen will packages at the Office Depot. While you can do that online or at the stationery store, I don't suggest it because more often than not, it's not going to have the result that you intend.
So now, explain to me what the difference is between a power of attorney and a executor of an estate.
Okay. The power of attorney allows the attorney in fact, that's the person who has the power now to speak on behalf of the person granting the power. For example, PC, if you were to give me power of attorney, then I would be named Oronda Smith, the attorney in fact on the document. And whatever that power of attorney says I can do on your behalf, I would be able to do it. For example, I might be able to sell your property or open up bank accounts or pay your bills, things like that. Anything that you could do, if you if you give someone a power of attorney, they can do it on your behalf. So you have to be very careful about who you designate as your attorney in fact,
Right.
because they can act on your behalf and you can become liable for it. The executor on a will, however, powers of attorney end at the time of death. That's the most important thing to know. And once that power of attorney ends at the point of death, that's when the will kicks in. The will designates what happens with your belongings after you die. It's something you have put into place before you die so that we can know what your wishes are once you pass.
I just want to remind our audience that we are speaking with Oronda Smith. She is with the O.M. Smith Law Group, LLC. One more question, Oronda. What happens if you don't have a will at all?
If you don't have a will, the state determines the order in which people receive your assets. So there's a Georgia statute, and let me give this disclaimer. I am a Georgia attorney and I'm licensed in Georgia only. So there may be some differences in each state, or there likely will be some differences in each state, some minor, some major. But the state laws have designated the order in which and the proportion in which your beneficiaries or your heirs receive your property if you don't have a will. For example, you may be separated from your spouse, but you may have children. If you don't have a will in place and you don't have a divorce, regardless, your spouse gets at least 1/3 share of your estate. They're entitled to 1/3 share of your estate.
That's because she's still married to you.
That's because your spouse is still married to you.
Got it.
Yes. If you had a will in place, you could designate how much or what proportion somebody receives something from your estate. Regardless of the spousal issue, you just may have particular things. For example, you may want to leave your main house to a child, your vacation home to a different child, and they don't get along. If you don't have a will in place, what will happen is both of those children will be equal owners of both of those properties, and that can create a problem. So the will just gives you the opportunity to clarify and designate things in the way you want and not have it left up to the state. Up to the state. So in the state of Georgia, for example, the first beneficiaries of an estate by state law, if you don't have a will, things get divided evenly between the spouse and the children, with the spouse receiving at least 1/3. So if you have one child or two children, then it divides pretty evenly. It gets a little bit messy if you have 3 and 4 plus, because the spouse gets at least 1/3, and then those 4 children are dividing the other 2/3. So this is where you start using your elementary and middle school math and your fractions and percentages. But
Okay.
spouse and children first, not just the spouse. A lot of times people think I was married to the person, it all belongs to me when they die. Not so.
So let me ask you this: What about heirloom property that's in the house after a person dies? Is there any way to keep that from going into the pot that would go to the spouse? Let's say if the spouse is not the mother, um, and is there a way to articulate who would get what out of the heirloom property?
So that's another reason why it's very important to have a will, because particularly in blended families, this happens quite often, where there's a fight between the new spouse and the children of the first spouse. And because if you don't have a will, like I said, the children and the current spouse divide everything, and that may not make for the best situation. And they divide everything, including the property, the personal property in the home, whether that's heirlooms or not, unless it's designated in some place that this was an inheritance. But in order for that to be proven and designated, that involves litigation, and that just increases cost and heartache and everything. So that's why it's best to take the time to plan your estate now, So you can write everything down, those particularly valuable items, and designate where you want them to go.
Okay, now you're also a real estate attorney, and I'd like to switch the subject for just a second here. Uh, which in your opinion, which is the most advantageous to a real estate investor? Would that be a TIC or an LLC? What would you say?
Okay, just to clarify for the audience, when we talk about a TIC, you're referring to holding something as tenants in common versus a LLC. And I'll say it depends. It depends on what your goals are. The most protective thing and the thing that I would advise most often is to have an LLC. The LLC protects your personal assets against any claims. Only the LLC will be liable if something happened regarding that investment property. If you hold something as a tenant in common in your personal name, then that subjects you personally to liability. Also, as tenants in common, it divides the asset in the into the percentage of the number of tenants there are. For example, now you only have if you have two investors that have bought that property, you have a 50% interest. You each have basically a 50% interest in the property, as opposed to if you have an LLC, the LLC owns a 100% interest in the property, and in the operating agreement or in the organizational documents of the LLC, you can designate the particulars of how that property is divided and all the benefits that any of the owners, also called members of the LLC, operate in regard to the property.
Gotcha. George, you're into residential real estate. Do you have any questions for Oronda?
Absolutely. I mean, this has been a very informative conversation. I really appreciate all the knowledge and wisdom you've given us about trust and will, and then skipping over to real estate. Um, yeah, as a real estate agent, how important do you think it is to have a attorney representing you in a real estate transaction?
So in the state of Georgia, it's required that an attorney be involved and be in control of the closing from the start to the finish of the transactional process. We, of course, allow in Georgia, different from other states, there's a specific state law that allows licensed real estate agents to write the contract. But once the contract is in place, it's required that in order to facilitate the transaction, a licensed Georgia attorney be involved. What that means is that there is one attorney that oversees the entire transaction. And in the state of Georgia, different from other states, separate parties don't generally have their own attorneys. That's because the contract, by the time it gets to the attorney, has already been negotiated. And the contract that most real estate agents use in the state of Georgia has been tirelessly litigated all the way down to its finest terms. And so there are not a lot of issues involving the terms or regarding the terms. But the closing itself and the completion of that transaction and the issuing of the title insurance belongs to and is required to be done by a Georgia licensed attorney.
Yeah, basically what you're saying is, so the closing attorney, which is appointed at the time of the transaction, is basically the attorney that's involved in the real estate transaction.
Yes, and that person is designated at the contract phase. There's a line on the contract that the contract has to designate the closing attorney, and that's the person who facilitates the transaction, and the either the closing attorney themselves, that law firm, or sometimes they have separate title companies up under them or related to them that actually issue the title insurance to that property, which, as an aside, is very important that people have. A owner's title policy is optional in the state of Georgia, but yet it's a very important piece to have and to pay for at the time of closing.
Wow, all important information. That's thanks for clarifying that for me. I've got one other question, actually skipping back to your wills and trusts. So, for our audience, and, a lot of our audiences are young folks. At what age do you think an individual or a couple need to start looking at, getting their affairs in order and looking at preparing a will or a trust?
So it really depends on when you have assets. I say everybody has an estate. You can start preparing your will in the state of Georgia at the age of 15. So, and some children, I happen to know a few who by inheritance and some other means, and maybe through if they've been modeling or acting as a child, have substantial assets that young. And it's prudent that they go ahead and put that in place at that young of age. But anytime you have any life changing incidents as an adult, you want to put something in place. For example, if you have a child and then you want to update it accordingly at each child, you want to make sure you update your will. You have one in place, and then you update your estate planning documents. If you buy a house, if you sell a house, all of those things, if you have major life changing incidences, you definitely want to do it if you get separated or divorced. Any major life changing incidents, or if you suddenly acquire, if you get in a new investment opportunity and now you're in an investment group, or that LLC that we talked about, that company, all of those things impact your estate plan. And it's important that you begin one and execute at least the base documents and then update it accordingly at those changes.
Oh,
Okay.
Rhonda, for the sake of the audience, why don't you tell the audience how they can get in touch with you if they have any questions or concerns or need your service from a real estate point of view or from an estate point of view?
Thank you so much. Um, Again, my name is Oronda Smith. The firm is O.M. Smith Law Group, LLC. You can find me on the internet at omsmithlaw.com, and you can contact me via phone at 678-804-5533. The easiest way is to go ahead and go to that website, omsmithlaw.com, and there is a contact form on that website that goes directly to my email. And I look forward to meeting and addressing any concerns you have.
Great, great, great. Well, we certainly appreciate your time and your knowledge that you've shared with us today. It's been uh, it's been quite a knowledgeable piece of information. George, do you have any words of wisdom for us today before we sign out?
Well, Paul, like I said, first of all, I want to thank Oronda for coming on the show and sharing all that great information. Sometimes in our life we get busy and we forget about, estate planning. And that's why we thought here at the Crotchety Old Men podcast, it was important to bring somebody on of her caliber and stature to talk about some things that's just as important. Because, we talk a lot about finances and we talk about health and things like that, but it's also important to talk about the legacy that we want to leave for our children, and the only way you can do that is through wills and trusts. So I think it's very important that we get into this subject and we're able to provide this information to our listening audience. And here again, as the Crotchety Old Man podcast, please continue to tune in. You can find us on all your favorite podcast platforms: Apple, Stitcher, Google. We're on all of those, and so please tune us in, download us, and continue to listen to us, where we continue to bring you those subjects that will help you, live a successful financial life and continue to prosper. As far as the words of wisdom, Paul, you know me, I'm going to always keep it simple. So I'm going to just basically say, in all you're getting, get understanding. Crotchety
My
Old Men
man.
signing out. Peace.
Peace, y'all.